I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are bringing you compilation number 206, and in this compilation we will be focusing on one judge, that is Judge Corey Wiggins out of the state of Michigan. And if you follow the channel, remember I told you guys last week that I would be bringing this compilation because there was a defendant, a sovereign citizen before Judge Wiggins by the name of Mr. Leffers, and his proceedings were pretty long. We showed 3 of them in 3 different compilations in the last week and a half, and I told you I would be doing this week where I would put Mr. Leffers' all 3 proceedings all in one compilation, just in case you guys hadn't seen all 3 of them and you only saw different parts. I wanted to make sure that I put it together so that way it would be easy for you to watch. You won't have to go searching for it. So today, that's where we are in Judge Wiggins' courtroom for Mr. Leffers' 3 proceedings. Don't forget to like, comment, share, and subscribe. If there's any commentary, it will be left in from the previous proceedings. Also, chapters will be added just in case you've seen one of the 3 and you want to jump around. That is totally up to you. And now it's about that time. Let's go ahead and jump into 206.
Oh, I thought he was. Court calls the people of the state of Michigan versus Philip Andrew Leffers, case number 26819FY. Appearances, counsel.
Please all for the people.
Good afternoon, Your Honor. Bernard Jockins appearing on behalf of the defendant, Philip Leffers.
So are you Mr. Leffers?
Are we on the record, Your Honor?
We are. Are you Mr. Leffers? Is it Leffers or Leffers?
I am Philip Andrew Leffers, being duly sworn, hereby declare my intentions to be a Michiganian national by birth, but not a citizen of the United States. I am here on special appearance in this case as authorized representative, beneficiary of the estate, Philip Andrew Leffers. I appear before this court without waiving any rights, claims, defenses, or remedies available to me at law, equity, or under trust or fiduciary law. I have.
We can't really hear him.
Sir, can I get you to speak up so that
Yes,
so that we can
sorry,
get a
sir.
clear record?
I have my CPAS. I have been working very hard to understand and overstand a lot of things in the past. No disrespect, just complete forwardness. I move the court to take judicial notice of the Michigan Constitution of 1850 and the United States Constitution of 1788. And your oath to it, sir. Yes or no, please.
The yes or no to what?
This is a copy of your oath of office, sir.
I don't take anything the judge tells me to.
Bailiff, I'll take it.
Yes, sir.
Yes, that is my oath of office and has my signature on it from January 22nd, 2025. You can hand that back to him.
Any administrator or executor that refuses to immediately dissolve a Sesta QB trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. Per the United States Constitution, Article 3, Section 2, Clause 2, clearly states that when the state is a party, whether defendant or prosecutor, the Supreme Court has original jurisdiction. Supreme Court decision 1796. There, every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Pruden v. Neely, 2 NC 338, 1796. And don't forget the law of the land, where the general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 2 Tranche 137, 174, 176, and 1803. And where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, page 491. The United States Supreme Court has repetitively held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. versus Will, 499, U.S. 200, 216, S period CT period 471, 66 L addition 2B 392, 406, and 1980. I Cohen versus Virginia, 19 U.S. 6 week 264, 404, 5L edition 257, 1821. 5 U.S.C. 556D, 557, and 706. Once due process is denied, all jurisdiction ceases. Due process has not been properly followed on me. I have not been given full disclosure of everything, including the accounting information, the bid bond, the performance bond, the payment bond, all accounting involved in this, as well as I have not been given the almost 1 hour video of the security footage from Save-A-Lot. Only 14 seconds is what I was informed from Mr. Jockins, and when I asked him for it, he denied me access to it. So I am not being given a fair shot. So I have removed him as my counsel. I got lost. Please.
Judge, I can't see Mr. Leffers in there. I don't know if the court wanted me to respond.
Sure, let me adjust the camera. I'm sorry for that.
Your Honor, I'm just going to back up and give a little bit of procedural history to the court. I know that the court always reviews the files. I'm just going to explain where I'm at. When I was initially assigned counsel on this case, I took the time and opportunity to review Mr. Leffers and consult with Mr. Leffers, not in person, but I did. With that information that was provided to me and speaking with other witnesses, family members, potentially, I decided it was appropriate to file a motion for a competency evaluation and inevitably criminal responsibility in this action. And the court could take notice to the Mr. Leffers' remarks, motion, etc. Judge, I provide everything, to, Mr. Leffers, as I do for all of my clients. And I do follow the Michigan Constitution, the United States Constitution, and every case I have is as important as anything that is going on. With that in mind, Judge, I got notice of this was supposed to be, I believe, on the 7th or 8th of April, and I had contacted the clerk indicating that I didn't think that it was appropriate at that time because we still do not have the evaluation that was returned from the MDHHS regarding the forensic evaluation. And maybe the court can understand the reason why I requested this evaluation, regardless if something was like a ChatGPT sovereign motion. If the court wishes to remove me, I am fine with that. If somebody doesn't want me to represent them, that's fine. But at the same time, I meet all of my obligations and do everything that I am supposed to do with each client, even more so. So with that in mind, Judge, the only concern that I have is that we're still waiting on a forensic evaluation that Mr. Leffers had participated in approximately a calendar week back.
We got the motion. But that, order.
Yeah,
What did I do a calendar week back?
I don't show where I see where, at least I can't put my hands on it now, but I remember you filing a motion. But I have not signed an order for a competency evaluation yet.
Well, with that in mind,
Because-
Judge, I don't know what the court would like to do. If the court would like me to get, I thought that I had provided a competency order, SCAO form. If not, Your Honor, I'm fine with Mr. Leffers proceeding on his own.
Your Honor, I object.
Hold on. Yeah, so I show that there was a motion filed by Mr. Jawkins on March 23rd for motion for evaluation of defendant's competency to stand trial. And actually, I believe it was that same day we received the defendant's motion, Mr. Leffers' notice of self-representation and motion to withdraw. And then the next day, we received an updated copy of that notice of self-representation and motion to withdraw. So I believe this is the first time we're here since these have been filed. And it's generally the court's practice to have a hearing before just granting a competency request. So that was one of the reasons we were here today. So we were actually set for a preliminary examination and these motions. So I believe it obviously is not appropriate to do the prelim today. And so that gets us to the motions. So I guess, Mr. Jawkins, I'm going to turn to you quickly. Your take on the situation. I know you said that you are okay withdrawing, but do you believe that there has been such a breakdown as to require you to withdraw?
Your Honor, I cannot communicate with this individual, and my apologies. When I had communicated with the clerk's office, I was it was indicated that the exam was taken off the docket, and that might have been an email thread as well. So I hope the court doesn't think I'm being deliberately derelict or anything like that. But
oh no,
these are the reasons why I filed this motion, Judge. But if Mr. Leffers would like to proceed on his own, I'm not interested in. I'm the captain of everyone's ship, and I leave it at that. I really, I don't have a good feeling about that when someone files a motion to withdraw, and if I am out there. However, I still think it's appropriate for a competency evaluation. That's the reason why I had filed that, Judge.
All right, thank you. Now, Mr. It's Leffers or Leffers? I know you said and I apologize.
No. not entering into any.
I understand.
It is old order of conduct. Living in Quincy, Illinois. We were there for the Oktoberfest. They do a German exchange in Quincy, Illinois, where I was. Ran into a gentleman, family lineage, and actually tracked down all of the Leffers clan. And he gave me old records from the 16th century. It's Leffers.
Leffers.
Now, it depends on which one you go with. There were over 7 Leffers families. They were all together.
Okay.
Except 2. And then I think it was like 80, 100 years later, it jumped to like 13 or 14 in that village.
Okay. So I want to make sure that I'm following your request. And I understand that you have some arguments as to, one, whether or not the court has lawful jurisdiction, lawful authority, and also a question of whether or not you have been provided with appropriate due process. Couple that with is your request to represent yourself. Am I correct on that?
Yes.
All right. And are you requesting to represent yourself?
Yes.
You do understand that you have the right to have an attorney that either you could hire or that the court would appoint, as opposed to you representing yourself. Do you understand that?
Yes. My creator has placed a lot of friends around me with wonderful information that I never knew. And I'm grateful to know this now. I'm sorry for being caught in dishonor in the past. It will not, Yahuwah willing, happen again. I understand my place, and I have always tried to respect the way that things are. Which is why I need to finish this as well, sir, please.
Go ahead.
And with discovery not being met, there are no medical records, let alone a psych evaluation proving any type of trauma. No harm has been done. No pain has been inflicted and no property was damaged. I have entertained the contract deal of alcohol testing, and I don't drink anymore. And yeah, that was an issue. Not anymore. But in the same token, I can no longer contract with it, knowing that everything's a contract. As you can see from the tests, I even stopped smoking weed and only smoked it right before bed. Since the motorcycle wreck, things have been very uneasy trying to sleep at night. Period. Definition of presumption. An idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge. That presumption, the presumption, then has no standing or merit in fact. Probability. The extent to which something is probable, the likelihood of something happening in a case. By definition, then, this is not substantive, as it is only a probability of what may be and therefore has no substance in marital fact. An incorporated state court does not operate according to any true rule of law, but by presumption, color of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, agent and agency, incompetence and guilt. Section I, the presumption of public record is that any matter brought before a state court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is private bar guild business matter, unless stating openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under private bar guild rules. I, Philip Andrew Leffers, the undersigned formally challenge the presumption of public record, as it is by definition a presumption and by definition has no standing for marital fact. Section 2I. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. I am back in place. I do not need a trustee over my estate. Will govern as my creator wants me to. I, Philip Andrew Leffers, the undersigned formally challenge the presumption of public service as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section 3I. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartiality, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. I, Philip Andrew Leffers, the undersigned formally challenge the presumption of public oath as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. IV. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability unless openly challenged, and their oath demands, as it is here, the presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from any personal accountability for their actions. I, Philip Andrew Leffers, the undersigned, formally challenge the presumption of immunity, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. B, the presumption of summons is that by custom and summons, unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, or witness. In jurisdiction of the court, attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and the existence of guilt stands. I, Philip Andrew short-term memory was wiped out. I, Philip Andrew Leffers, the undersigned, formally challenge the presumption of summons, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section B, I, the presumption of custody is that by custom and summons or warrant or arrest, unrebutted stands, and therefore one who attends court is presumed to be a
Judge, I'm
thing.
sorry, I'm objecting at this point.
And
You know, right now, there's
hold on.
nothing that's relevant. This is just rambling and rambling and rambling. Chat GBT, sovereign citizen stuff.
Be a thing, and therefore
Right, Mr.
be
Leffers, I need you to stop for a second. So this is what I'm going to do. Mr. Jockins, I'm going to allow you out of the case. So I'll sign an order in that regard. So you're free to go. Sir, that I know you have a lot to get out there. Now, I know, and admittedly, it's been a while since I've seen this type of material out there, but I have seen it, and I'm familiar with the position that you have. And I understand that you are essentially challenging the authority that one, I have as the judge, two, that this court in totality has, and three, anything that the any charges that the prosecutor might have. I can tell you that based on what I'm hearing today, I'm not going to allow you to represent yourself. I don't think, well, I understand that those are your beliefs and your feelings. I don't think that represents a true grasp of the reality of how this republic works, how this state works, and how the court works. And so for you to represent yourself, I think is going to potentially do more harm than good for you. So what I'm going to do, as you've heard, I've allowed Mr. Jockins out of the case. But what I'm going to do is I'm going to make another referral to another attorney for you. All right. It's not that I don't think that you're smart enough to handle the case. That's not it at all. I have there's some procedural issues here, and that is, I'm going to be honest, will probably go to your detriment. And that's and you've got some pretty serious charges here. One of them is a 4-year felony. Means, you could have up to 4 years in prison. So I want to make sure that you have the appropriate legal representation. And for that, I'm going to deny the request for you to be able to represent yourself. So we'll make another referral to the public defender's office. It might take a little bit of time because for whatever reason, this case went to a conflict attorney, which tells me that the public defender's office has some sort of conflict. What that conflict is, I don't know. But that's how Mr. Jockins came in. He's a a conflict attorney that they work with, so they'll have to reach out and find another attorney for you. Okay?
Your Honor.
Yes.
Move the court to dismiss all charges at the same time. This was case number 26-891-SN-1, which came to fruition because of these false charges that have been placed upon me.
So,
State, and had the officers actually done their due diligence and looked at the video footage, which is almost an hour long, proving I never ran anyone over, never threatened to, so no harm was done. Everything should have stopped right then and there.
so there's a procedure in which to do that, and there's a proper hearing at which to request a dismissal of the case. That is not today. There's a proper time and place to do that. For what we're here for today, that's not it. Obviously I can't tell you what that date is or what the procedure is, because that would be giving legal advice that I can't give as a judge, which is another reason why I think well, I shouldn't say why I think, another reason why I believe that you need to have appointed counsel to assist you with that, and to evaluate all the potential discovery issues out there that you've brought up, to evaluate your defense, and to direct in a manner which will be a beneficial outcome for you. So what I'm going to do is we'll reset this case for another day. We'll get another attorney appointed for you, and we'll have that attorney get in contact with you, and then you can discuss with them your concerns and the best procedure for moving forward. Okay?
Problem with that, though. I didn't know this books I do now. It goes against the Constitution. Even if you do have conflict. So if you want to push this to the Supreme Court, I'll go and stand in front of the Supreme Court.
Well,
I'm okay with that.
that's certainly your prerogative to do that. So, and that's why we have the appellate courts in place.
So I need a ruling, sir. Are you going to dismiss these charges on lack of jurisdiction and a violation of my constitutional rights? Article 3, Section 2, Clause 2.
All right, Mr. Leffers, I have found that I'm not allowing you to represent yourself in the court. So it's not appropriate for me to give a ruling today because I'm not allowing you to represent yourself. That is something that an attorney can assist you with. I will state, as I stated before, today is not the proper time to entertain that request for a dismissal. So you can go out to the front window where you checked in, and you can get your next court date, and hopefully we'll have an attorney appointed for you by that date.
What are you thinking about the dates, sir?
My guess is it's probably going to be next Tuesday. Next Tuesday at, let's reset it for a PCC.
10:30.
10:30.
What would that date be?
That date is April
21st.
21st. Will that work for you?
Yes, sir.
Okay. Like I said, you can go out to the front window where you're checked in, and they'll actually give you that paper date, so you'll have that notice. And then, like I said, hopefully we'll have an attorney for you by then. If not, we might have to adjourn it again.
Now, question, because at the same time, can I get the rest of this covered then? Because it hasn't, I need the accounting, Mr. Dawkins, and in the small statement of the office, it's almost a video for an hour, but he couldn't get it downloaded, so he recorded with his phone, and apparently it's only 14 seconds. And
So-
then there's discrepancy upon discrepancy and timestamps literally ranging from 5 minutes to stating that I'm at the hospital when I was in the back of Patrol Cruiser 10 at Save-A-Lot. When the officer gave his sworn statement to the magistrate about the warrant after he falsified other information.
So there's a process to go through to request discovery. Your attorney will know that process because you're not representing yourself. That request needs to come through your attorney and through the prosecutor's office, because it's not appropriate for the prosecutor's office to have direct contact with you as well, due to potential ethic concerns and violations for that. So, but yes, you are certainly entitled to that. So whoever your next attorney is, should be able to obtain that and sit down and go through it with you. And then if for whatever reason, if that doesn't happen, there's some other avenues then that attorney could take, or you could come back and request the court to determine whether or not that attorney should be removed as well. All right, thank you. Have a good day. Don't forget to stop at the front window. This is case number 26819FY. Ms. Dull appears on behalf of the people. Mr. Leffers appears in the courtroom but refuses to enter the well. I do remember this from the last time we were here last week. The court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right.
Your Honor, is the court going to reset the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments on the United States Constitution. What say you, sir?
I addressed you last week about about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case. Which once again is why Article 3, Section 2, Clause 2 of the Constitution exists. The state cannot prosecute this because it always going to rule in favor of itself. That's the law. Also, discovery hasn't been met because I was never given a full accounting about the bond relationship and the accounting on the bid bonds, performance bonds. And I am not a 14th Amendment citizen. I am a Michiganian, state national. I have corrected my status. I have spent a year doing it.
What do you mean by that? No, you tell me what you mean by that. I don't need you to look at paperwork. You said you corrected your status, so what do you mean by that?
Upon finding out about jurisdictions, 14th Amendment citizen is bound by your jurisdiction, sir. I am not a 14th Amendment citizen.
What are you?
I'm American state national.
And what is that?
That is a man or woman born to the state in the territories of the Confederation of the Republic that made up this wonderful place and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the US Constitution.
No, sir, this predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Yes.
Supports it.
In the First Amendment, we are one. This is my wife, Jelaine. She's been with me for 24 wonderful years. She has had my back. She has helped me grow and understand and overstand so many wonderful things. The Constitution is set up to protect rights. And I have the right to use everything at my disposal. The Constitution is at my disposal, in addition to the supreme law of the land. So is the Bill of Rights. Not to be in dishonor.
How does the Michigan Constitution play against the US Constitution?
The Michigan Constitution, as wonderful as it may be, is not a Constitution. The corruptness that went into it destroyed it. Though it may hold some lingering truth, if you change 10% of 100% of the story, you have deceived everyone that you tell that story to. And they will never be able to defend themselves properly. They will never know how to manage themselves properly. If the truth was to be told, then the decision, the rightful will choice would fall on the people. And I am one of the people. Which is why there's also another conflict of interest. The state cannot prosecute me because I am the people. So is my wife, and so are our children.
So it's your belief that the state cannot prosecute criminal laws against its citizens. But if you were a citizen of Texas and violated a Michigan law, would the court then be able, or would the state of Michigan then be able to prosecute that person?
State of Michigan. The Texas.
No, hold on. It's Mr. Leffers is the one who has.
Well, as I stated,
We are one in our
First
state.
Amendment right.
Okay. Mr. Leffers is the one who's before the court. Mr. Leffers is the one who gets to speak on the record.
That would be against my First Amendment right.
Okay, I can see how this is going to go. So, Mr. Leffers, you are not releasing any rights that you have. But we're going to reset this then for another probable cause conference next week. And hopefully by then we will have counsel appointed for you. And you can discuss your issues with your appointed attorney.
So I do not accept. Also, I am here on special.
All right, Mr. Leffers,
In the case.
Mr. Leffers, you need to stop. All right. I need you to go out to the front window where you checked in and get a copy of your next court date. Because I'm not going to allow you to interrupt the business of the court. And as you can see, you're getting pretty close to that. I'm not saying that you're wrong. I'm not saying that you're right. I'm just saying, again, this is not the forum. That's not what we're here for today. There's a procedure to go through for motions to be filed and to be heard. And as I said, I've appointed counsel, even though that hasn't happened yet, to make sure that you are fully apprised of all the options, the way the court works, the way the laws interact with each other. And I highly encourage you to listen to that counsel, that attorney, once they're appointed. You're not the first one to have this situation before the court. You're not the first one to assert these rights. But there's a way that things work, and your grasp of it right now, I believe that you are mistaken in how the laws interact with each other and how the constitutions interact with each other, how jurisdiction works. So once again, I'm going to ask you to go out to the front window where you checked in. I understand you're not waiving any of your rights, but I'm going to ask you to the front window where you checked in and get your next court date. And then we will have, again, we will continue working on getting counsel appointed for you.
Judge asked. Nope. Grab it up yourself. It's gonna be over.
Thank you, sir.
Thank you.
Have a nice day.
You too.
Yeah, well. So.
I'm also going to ask that any phone be placed in a pocket or purse in such a way as it cannot be seen from the courtroom. If you could stick that in your side pocket, sir, I'd appreciate it.
Deep front pocket.
All right, thank you. I appreciate that. So appearances, counsel.
Lisa Doe for the people.
Robert Hertel for the Defender's Office. Your Honor, Mr. Champion was in Misaki this morning. I'm sure the court also took note that what we, from the Defender's Office filed, we included a qualifier of it not necessarily being endorsed by the Public Defender's Office. I wanted to make sure to stress that.
Correct, I understand that. So, Mr. Leffers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hartel. So, Mr. Leffers, we're already past noon.
Sir.
So what I'm willing to do is, do you think you can state what you want to state within will 5 minutes be enough time?
I'll do my best.
All right, so I show we're at about, well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other, so go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. Your Honor, I am Phil Leffers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. Your Honor, I voluntarily appear in this court today on special appearance. I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments and the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added. And Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration. Or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court
Okay, all right.
on a federal indictment, which as a national, we're in different jurisdictions, sir.
So I understand you want to represent yourself. I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things, most recently about my hometown, the past 2 judges have been removed by the tenure council. So canon 1 through 5, indeed, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even unpro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay, so I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory is gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So, so as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all 3 parts here. So I
watched your videos while you were a judge. I watched the one of the 2 gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same 2 officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did. And I watched 2 other videos, which they fully got what they deserved. They broke the law unequivocally. But those 2 gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's not $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these two officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property. The officer also stated that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus, false in one thing, false in all. And if you begin it by a lie, how can you be credited to be believed at all? So the officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak.
Correct.
So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So where I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, proper, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, we found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let me ask you, and I understand why we're getting a little heated, but
Sorry.
hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank, because again, I'm on a time clock here.
Correct.
So let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the police report?
Defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point. And it crashes every single time.
But they at least
RJ stated, he's like, I just watched all of these. I don't understand what's going on.
But they at least attempted to play it for you and then it crashed.
I wasn't.
Presumably.
Discovery means that the evidence goes to me.
No, I understand, but just focus on my question for a minute. My question is, were you given the opportunity to at least try to watch the video? I understand there were some technical issues, but did you at least,
Yes.
You were given that opportunity?
Yes.
And were you given the opportunity to review a police report? Maybe not handed, but did you at least, and don't talk about what they told you because I don't want to get into attorney-client privilege, but did you at least have the opportunity to generally say, okay, this is what the police report says, what do you say, and then kind of merge the two?
The insinuation of attorney-client privilege against her, please.
Well, I had to be careful of that because I had appointed counsel.
Correct.
So I'm setting that aside right now. So at least by the time that you had counsel appointed, that's what I'm considering attorney-client privilege.
All right.
Not from here forward, just during that time period that you were with either Mr. Jockins or you were with Mr. Champion.
Yes.
Did you at least have the opportunity to go through a police report? Maybe not being handed to it or handed it.
We're given the addition to the police report. We were given the police report originally by Mr. Jockins,
Okay.
which at the bottom of the police report, and there's no signature of any witness. It was Officer Dot, right?
All right, Mr. Leffers, I need you to focus on me because this is one of the rules of the court.
Yes.
It's not appropriate for you to be interacting with a member of the audience. And I realize that you're married and you're one, but
Memory.
yeah, I understand. And that's where why I have concerns about the memory aspect and allowing you to just represent yourself on your own. And that's one of the reasons I'd asked that question about whether you'd be open to of counsel situation where they're there for you to talk about the case. Sorry.
As long as it's completely, and if we have to sign an NDA, fine. I would prefer not to. I mean, I have nothing to hide. But if we have to sign a contract stating, I'm not contracting with this, my constitutional rights are broken. I know what lawyers are about. We've read it. Now, that's not saying everyone's that way because there's moral and honorable. But most of them just want that money. And I know where their allegiance lies, just like I didn't know that a judge also has a banker's oath. I didn't know any of that. But yes.
So, all right.
I will do my best.
So it sounds though that you want to represent yourself, but you're okay with having an of counsel position that you can talk with, make sure things are being filed properly and that sort of thing. Not that they're representing you, but just to be able to bounce ideas off, so to speak.
I reserve all rights through equity and trust law and under the Constitution. And as long as that's not violated, I don't have a problem with that.
All right.
That's what I'm saying. Now,
So if I allow you to represent yourself, are you going to be able, again, to comport yourself? Because realize that in the grand scheme of things, right? The Supreme Court's up here. I'm the district court. I'm way down here. There's lots of courts to get through before you get to the Supreme Court for appellate purposes. So a lot of the things that I'm left to decide are necessarily what the law says, what the Constitution says, the Constitution that is currently before me. There isn't, the appellate courts would have to tell me I'm wrong. Do you understand that?
sir, but we could read the Constitution.
No, I understand that, but what I'm saying,
Article 3, Section 2.
but what I'm saying is because I've also noticed that in some pleadings, you said that you're not a 14th Amendment citizen, but hold on, but yet in the last pleading, you said I was violating your 14th Amendment.
It's a compilation of both.
Well, but
sir.
see, it can't be. So,
But it is,
but see, that's where things kind of go off the rails, because you would agree with me, right? That if you are not a citizen of the United States, let's say you go to Japan, for example, all right? Are you not then subject to Japanese law if you're on their land? Whether or not you're a citizen, you would still be subject to Japanese law, correct?
No.
No, it's not an analysis. It's
If
you
the
still
presumption-
retain your U.S. rights and citizenship, but the minute you would step into that territory of Japan, you're then subject to their laws.
Anything that abrogates the Constitution and its amendments is unlawful.
But the Constitution doesn't apply in Japan, right?
Well, it does. Because what national are you? That's also protected internationally to the international court.
Mr. Leffers, I will allow you to represent yourself, but I'm just forewarning you that you are going to be held to the same standards and procedures, whether or not you agree with those standards and procedures, because that is what I'm bound by. The standards and procedures that have been set by the Supreme Court, the laws of the state of Michigan. And when I say the Supreme Court, I mean both the Michigan Supreme Court and the United States Supreme Court. the laws of the state of Michigan and to the interpretations and case law of the when it comes in regards to interpretations of the U.S. Constitution and the Michigan Constitution. Now, I realize that because you cited the 1850 Michigan Constitution. In this court's eyes, I believe it's the 1963 is the date. Don't hold me to that exact date, but the latest version of the Constitution. When citizens are able to pick and choose which things they agree with in the Constitution and which things they don't agree with the Constitution, that's where things run afoul. And that's where it takes a court a lot higher than me to make that decision. So it's a long-winded way of saying is I am only going to be bound by what is appropriate for this court. If you need to take it to higher courts, that's certainly your prerogative. But moving forward, can you at least agree to that?
Okay, so from what I remember is that the judge or the prosecutor, depending on how they file it, in which the prosecution filed it incorrectly, especially after finding out about my nationality status. Nationality status is protected by the Constitution, and the Supreme Court has ruled on that several times over. Now, the prosecuting office is supposed to refile the paperwork then and go for a grand jury indictment.
So there's a proper procedure in which you have to go through to do that, and this is not that proper procedure.
And if the prosecutor doesn't want to do that, then it falls upon you to make the decision. Where the truth is what it is. And Ezekiel 3:18-9. If we are seeing someone in sin and we don't say something, on the day of judgment, whatever you have seen, for anyone you didn't say something to, you will be judged for it. So, sir, I respect you and your honorable ways that I've seen. The Constitution and my rights are being broken and trampled on. My due process is broken. I cannot get an impartial anything in this county.
So what'll happen is if I allow you to represent yourself, you would then be able to file the demands for discovery, and the prosecutor would have to turn over to you what they have for discovery.
Well, it's not just that.
No, but I'm just saying,
Well,
so that's one, that would alleviate one concern that you have.
yes.
And then I understand.
Information to be executed and relieved over to me, which entail all of it. The financials. 12 bonds that have been opened up.
So
the EE bonds,
they
the
can
I
only,
bonds,
so hold on, so they can only provide what they have at their
anything
disposal.
that is charged.
They can only provide what they have at their disposal. They can't go out, or they're not required to go out and seek information that, let me rephrase that. They don't have to go out and generate discovery. If they don't have it, they don't have it. Does that make sense? So if they don't have a specific bond that you're requesting, they don't necessarily have to go out and get that bond. Do you understand that?
With the paperwork I filed, with the UCC laws on them, it clearly dictates and describes all the evidence that I'm asking for. Now, the amendment,
So, and this is where you get to step in as the lawyer. What authority do you have? What case law do you have that says that the UCC applies in a Michigan state criminal charge?
the fact that it's tied to the case,
How?
because the bonds got opened up through the case number.
But
So the thing
So,
that's attached to
where
the
do you
case
get that-
number
where do you
is
get
my
that from?
Social security number. You can look it up on Treasury Direct.
But that's not my
No,
responsibility.
no, it's not.
So-
In due diligence and learning, we started looking. Multiple friends are helping. So they're pointing us in the right direction. So we have literally seen it, we have photographed it. over 12 bonds have been opened up with a numerical value over $500,000. As of right now, over $500,000 in EE bonds and I bonds have been opened up off of this case. The only thing attached to this case is my social security number, which my estate owns.
So who opened the bonds?
Well, I would have to be given time to file the paperwork, which I've already been filing. I've already filed with the Trade Commission on the fraud that I did not authorize these, and I want to see the wet ink signatures. I also filed for the fiduciary change with the Treasury Secretary. The ID will be coming back. That was wonderful. Because there's a few documents that I have to scan my ID for before I can submit them to the state to continue moving through for my nationality status in whole.
And who do you apply to for your nationality status in whole? Because you were born
a lot of stuff. A
You were-
lot of stuff. You got to set the IRS correct. You got to set the Treasury Secretary correct. I got to send a letter to the government. I got to send a letter to the head sheriffs. And like when we lived in Alabama, it was a sheriff's director board or whatever. They had a meeting every week. I'd have to send a letter of notification of the revocation of the driver's license and driving privately. And already switching over the titles to the trust, just running low on equity. Which is why the other reason, her case is tied to mine. Misconduct. They removed her as the victim. She can't use her place properly. And she's doing the best she can. We would both be working. I had to stop working because my foreman found out about my CFC. And he tried to squish me with 6,000 pounds of steel that I just got done welding up. That was the second job. That was DCL, Traverse City. Before that, it was Stage Right out of Clare. They loved me so much, they didn't want me going to third. They offered me first. After I got out of temp service, because I got into the temp service because I have documentation from the SOARS department stating you don't have to register because you are not a Michigan resident. We support jurisdiction and constitution. But once you sell your house and you're no longer domiciled in Adams County, Illinois, you have to get a Michigan license. So I registered in the private and have registered in the private of my own free will and volition to prove I am not a threat to a community. That if there ever is a problem, you can call me up because the only ones that can see me are y'all.
What do you mean by that?
When we moved down to Illinois, they sent a letter. They never would have prosecuted me. They never would have charged me. Here's a letter stating that as long as you're an Illinois resident, you will never have to register another day in your life. Wow, I was able to hold the job for 13 years. Didn't get pushed off, didn't get hit, didn't have people trying to kill me. That's why we left Michigan. And it went to our children in public school. They were tormented, tortured. But I have documentation proving all the way from Ottawa County, Ottawa, Cranville, Grand Rapids, Mecosta, stating I didn't have to register. And I am doing it of my own free volition to protect those that might think nefarious ideas about.
So because I noticed one of the pleadings that you filed before, you mentioned that you were I think you said you were a resident of Kent County?
Yes, sir. That's our in care of address.
Okay. All right. Now, so when you said that we're the only ones that are able to see you, are you talking about because of the registry?
Oh, no, that's been changed since I sold my house.
Okay,
The house was locked up for about 2 years because the neighbors were so bad. Liquid Drano bombs over the house, attempted arson of the house. Yeah, and we homeschooled.
so
Um,
when you said that we're the only one able to see you, I guess I need
Well,
some more
now-
no, hold on, I need some more clarification. What did you mean by we're the only ones who are able to see you?
Okay, so the SOARS department,
Okay,
when we first came back to Michigan, I contacted them. They said, well, we're gonna have to look into this. We don't really know what to do. So they got back with me, stated, you don't have to do anything. Like, what do you mean? Like, you don't have to register. You don't have to notify anybody anywhere you go in the state of Michigan. You're not a Michigan resident.
okay.
I'm like, okay, but I was charged in Michigan way back then. And I don't want anyone thinking anything wrong. The SARS department flat out stated, look, if you want to register, you can. We will keep you in the private registry section. We're the only ones that will see you are law enforcement. It's like,
Okay,
that's
so
it.
I know
Okay,
what you
I'll
mean.
do that.
Okay, all right.
So SOARS department and I, when I went to Ottawa County, Fillmore County Complex, they're like, wait, what's going on? You're not a sex offender. I'm like, no, I'm not.
So they were gonna register
They
you.
didn't know what to do. They had to get on the phone with the SOARS department. I was in that waiting room over an hour and a half, allowing them time to get everything situated. And then I willfully went on the sex offender registry that I didn't have to do because the SOARS Department of Michigan respects jurisdiction and constitution.
All right, Mr. Leffers, I am going to allow you to represent yourself. Again, we've got an understanding that you're going to do the best that you can to be compliant with the court rules. Also, I'll allow the public defender's office to remain on as of counsel so that you can reach out to them. Not saying that they're going to represent you, but they're going to be there for a resource for you. Okay? And so that means from here on out, you're going to be able to represent yourself and you're going to be held to the same standards as we discussed. And I can give you some leniency, but not a ton.
I gotta let you know though, this can't proceed. I cannot be a part of fraud.
But so Mr. Leffers, this is where we get into the procedural aspect of it. This is where you will be able to file motions. You'll be able to conduct the hearing. And then that's where you'll be asking me to make a determination as to whether or not the case goes forward. But understand there's only certain ways that can be done in a criminal matter. So just because you stand here today and asking for that, what I have is your word, but the prosecution doesn't have the ability to put anybody on to contradict your word. And so we would have to have an evidentiary hearing, which is essentially what the preliminary examination would be for. And that's the next step in the proceed. Well, actually, the next step would be for you to meet with the prosecutors, see if there's a way to resolve the case, which I understand if you don't want to. And then the next step after that would be what we call the preliminary examination. And that's where witnesses would take the stand. They would testify. You would have the ability to cross-examine those witnesses. You would have the ability to call your own witnesses. The prosecution can examine your witnesses or cross-examine your witnesses. And then you can make your argument then as to whether or not it's whatever the arguments you want to make as to whether or not the case should be dismissed. Today's not that proper time. That proper time is you're going to get it, but it's going to be at some different point in the future. Do you understand that?
Yes, sir.
All right.
May I say one last thing?
Yes.
Victoria incumbent onus from Bondi. The burden of proof is on the plaintiff that originally brought the charges.
That's correct. And when I say that you get to make an argument, you don't have to present any evidence. They can get up there and put on their witness, and you can argue as to why I should or should not move the case forward.
Okay. In the I need to be allowed full access to everything. Not, well, set up an appointment I get up at 2 a.m. I go to bed at like 12:30 at night. So I have a lot of time on my hands.
So what'll
I need
happen
time
is
to look at things,
you'll-
and having to set up
you,
an appointment.
so there won't necessarily be an appointment with the prosecutor's office. What'll happen, and now it's been a while, hold on. It's been a while since I've been there, and this is part of the procedural aspect of this. You will have to file a demand for discovery. All right. You'll have to file that with the prosecutor. Now that you are going to be representing yourself, you would file a demand for discovery with the prosecutor's office. Outline everything that you want them to produce, understanding that they only have to produce what they have in their records. They don't have to go out and find things to help substantiate your case, right?
Correct.
Now, they do have a certain amount of time in which to do that with. So it's not like you can file today and request it tomorrow. They've got a reasonable amount of time, which the Michigan Supreme Court has decided is 21 days to comply with that request.
Okay, that was a quandary that we came across. We've seen 5 days, 7 days, 21 days. We couldn't exactly pinpoint anything for sure. So thank you for clarifying.
So yes,
that.
the Michigan Rules of Criminal Procedure adopted by the Michigan Supreme Court says that they have 21 days to comply. If they don't comply within that 21-day period, then there's other avenues that you have to either force compliance, or if it's such a out disregard for the rule, it could result in a dismissal of the case. That's a very extreme based on just discovery, but that is a potential outcome there.
Okay, and all the times before this don't matter?
So all the times before, you were represented by counsel. So those requests would have had to have come through counsel, which is how Mr. Champion got it and how Mr. Jockins got it.
But that goes against what I was stating, and I objected to it.
I understand that, but again, that goes into the procedures that the Michigan Supreme Court have set up for the courts to follow. But now that you're representing yourself, you are in a completely different place than you were before.
May I be candid?
Sure.
So does that mean that all of the court dates up until now was the inquiry competency test?
No, nobody has requested competency on you. Well, Mr. Jockins did. Mr. Jockins did, but we didn't even get to that point. Yep. No. What we've been doing is, I want to make sure, because as I said, I'm the independent party here. I want to make sure that your rights are protected, that you're getting the adequate representation and the right information that you need in order to make sure that your rights are protected. Now, I understand that you might not agree with some of those procedures and it might not be moving as fast as you wanted it to, but that is why I had, I don't remember whether I had appointed requested Mr. Jockins an appointment for him, but I know I specifically, when we removed him from the case, I do specifically remember requesting another appointment of an attorney. Because again, once you step into the role of representing yourself, that puts you at a whole different level as far as compliance with court rules, procedures, appellate rights, as opposed to having representation. So I wanted to make sure that you had every available opportunity to you. Now, all these dates that you've had, they all go to what we call the speedy trial clock. So because you are charged with a felony, you have to be, because you're not in custody, it's a little bit different. But we all look at the speedy trial clock as being 180 days before you should be at trial. All right, because you're not in custody, there's some grace given to that. But all of these then look at whether or not who these delays should be accounted against. So all these dates you've had were not in vain. They're one to make sure that you're getting the appropriate representation, and they will be considered when it comes time to a speedy trial clock decision if you get to that point. You may prevail at preliminary examination. We don't have to worry about speedy trial.
In reading, if I agree then that means I'm ignoring all of the past times. That the things I've stated about the Constitution, Article 3, Section 2, Clause 2 are being ignored, and I'm okay with that. I'm not okay with that.
You're not saying that you're okay with that. What you're doing is you're going to get your opportunity to raise those issues. It's just not right now. It's going to be at a point, a couple dates down the road.
All right.
Okay.
I object to all of it,
All right. I'll note your objection.
but if I have to go through this, fine.
So I'll note your objection. I'll allow you to represent yourself. The public defender's office will remain on in of counsel capacity. We will reset this then for a probable cause conference. Now the other issue, hold on. The other issue is you had also filed a motion to set aside a default.
Yes, sir.
There has been no default judgments entered. So
That came in the mail. We didn't know what the heck was going on, no offense.
what came in? Was there a civil infraction with this?
Yes. It was slipped in when I left. I didn't fully
yes.
grasp.
There is a civil infraction?
It's a fail to pay booking fee.
All right. So
Sir,
I will grant that
I
request.
got an object to it though.
Yep, go ahead and object.
Sorry. My wife and I went in on a Saturday before I went and worked with Bob, Travis's cousin. And the gentleman on the phone said that the booking fee was $12 and you could pay it at the kiosk 24/7. So we went in and we paid the $12 and it apparently still stated that monies was owed, fiat was owed to the kiosk, which didn't make any sense unless all the dumping of whatever charges were added on. But we have the receipt for the $12 of the booking fee that we were informed personally on the phone from a Wexford County officer. And the website also says that it's a $12 booking fee. Then I got that in the mail. This is preposterous. This is nonsense.
All right, so what I'm going to do is I will set aside that default. And
Thank you,
then
sir.
we can deal with that in a normal course of business in regards to that.
Thank you, sir.
All right, so Mr. Leffers, you can go out to the front window where you checked in. Is there somebody out there to give him a court date?
Yeah.
And get your next court date, okay?
Yes, can we speak about that, please?
Yes, very briefly, because I'm
When-
now an
when are
hour
you
behind.
thinking?
So my thought is PCC would be reset for next Tuesday. Will that work for you or no?
Honestly, no.
Okay, so will the following Tuesday, which would be the 19th, will that work? Go ahead.
I need. It's not on the doctor's. 19th would be fine.
Okay, so we will reset it for the 19th. That will give you time to get discovery requests to the prosecutor. And it'll be set for 10:30 on the 19th.
Now, this means that I will be able to have all the discovery within my.
So remember, they've got 21 days to comply, but my guess is since they provided it to two different attorneys, they can probably get it to you within a 2-week time period.
Well, no, I'm not
So-
talking about the time frame, sir. What I mean is the actual tangible, me being able to download all these
Yeah,
videos
so-
on my phones. It's not going public.
So
It's not going public.
So what'll happen, I don't know how it works anymore in their office, but they'll either provide you a link to click on, or you'll get a CD to put into a computer. However they do it, that's how you'll receive it. I think they do it by link now, where you'll be able to click a link and download it, but don't hold me to that.
Now,
But you can talk with the prosecutor's office about the best way to get it to you.
now, there's a discernment with that one. If it's a link to a video, how am I supposed to make sure that that thing hasn't been doctored up or anything?
Well, that's where you as your attorney get to figure that out.
unfortunately, I don't have the accessibility of resources at my hands as a prosecutor does. So if I were to want to have a video authenticated.
So there's a process. So the court is no longer involved with appointing expert witnesses. Because you are indigent, you would have to then request through the public defender's office, which they're going to be of counsel, to see whether or not they have any funds available to hire an expert on your behalf. I'm not saying that they will. I'm not saying that they won't. I don't know, because they're their own independent office. But that's where your of counsel attorney is going to come in and maybe give you some guidance there. Okay.
Yeah, I object to all of this.
I understand, and I know your objection.
The constitutional right's been broken, man.
I know, but there's just because you think it has been, and I'm not saying that you're wrong. Please don't take it that way. But the prosecution has the ability to defend their case, and today is not that day. That day's coming. It's coming. I promise you that, but it's not here yet. Okay, so just bear with us a little bit.
Yes, sir.
All right. I thank you for your patience today and your cooperation. You can go out to the front window where you checked in.
I appreciate your kindness, sir.
All right. Thank you.
It was a pleasure meeting you all again.
Can we have Mr. Waters' case?
I'm not threatening you. Say one more word and that's 30 days. 30 days.